Hello and good afternoon, everyone. Welcome to this 2021 Public User Engagement event session on the HMCTS Small Claims Mediation Service. Thank you to Kirsty for presenting, and over to you.
Thank you. My name's Kirsty Swan and I am the Cluster Manager to the Small Claims Mediation Service that sits within HMCTS. Today I'm going to give you a brief presentation explaining what our Small Claim Mediation Service is all about and how we approach mediation. Our service started back in 2007 as a pilot, but later on, as it became quite successful, we then expanded it, and now the team is currently 27 mediators supported by 20 administrative staff. Mediators generally work remotely, but are supported by an administrative team which is based in Leicester in Arnhem House. Our jurisdiction is that we cover all cases, civil cases across England and Wales. I will give you more detail in due course about the types of cases that we deal with, but we generally deal with only small claims cases only, and parties do not have to pay any extra fees when going to mediation. The type of cases we deal with, we generally get cases are automatically referred to us through the bulk centres within HMCTS, where cases have not been allocated, and they either come through to us either through pre-allocation or judicial referral. We do not deal with claims involving the following types of cases: child support cases, HMRC personal injury over £5,000, road traffic accident involving personal injury claims, but all other cases are eligible for mediation. The limit on a small claims is at £10,000, so we don't deal with any cases over those amounts. How does the mediation appointment work? Well, mediations are conducted over the phone, and we generally try and aim for those to last in the region of 1 hour. The mediator speaks with both parties separately and in turn to assist them in reaching a settlement. All these conversations are confidential, and that's explained to both parties on the call. The mediator doesn't have access to the court file, but may be able to access pleadings and defences on certain cases. And this is so that they can find out from the parties each of their position and get it from first hand from either party about what the case is all about. The mediator agrees with each party any points offered around settlement they wish to put across to the other party for consideration. In relation to how the settlement is achieved, a standardised mediation settlement agreement has been developed within the mediation service. This agreement has 5 terms, which one set out the specific details of the settlement reached, details of what happens if the agreement is defaulted upon. By agreeing and making a settlement, it means that the case is stayed, and it also addresses in the settlement agreement confidentiality about what was discussed in the mediation appointment. And finally, the 5th term is about confirming the agreement is in full and final settlement of the case. And at that point, if both parties agree to it, the case will then end in the civil court. The terms of the agreement are read out and issued to the parties and then filed with the appropriate court. Now, I can give you some details on small claims mediation performance over the last year. Between October 20 to September 2021, the total number of cases referred to our service was in the region of 39,000. Of those cases, in the region of 36,000 were pre-allocation and around 3,000 were post-allocation. The uptake was in the region of just over 35,000. 15,000 cases were either abandoned, cancelled or not attended, and that's usually due to the fact that one of the parties cannot meet the appointment, and we either have to rearrange that, or unfortunately, if it cannot be rearranged with both parties, it does then lead to a court hearing. In that period, over nearly 21,000 effective mediations took place, and of those, nearly 11,500 cases were settled, which gave a settlement rate of in the region of 56%. A full-time mediator's aim is to carry out a minimum of 5 effective mediation appointments each day. Now, in the last year, we've been developing a more effective way of listing our cases. We used to have a system where each mediator had their own calendar, but we found that in certain circumstances where mediations were sometimes ineffective, that it led to spaces in our calendars, and it wasn't the most effective way of doing this. So what we've now done is we've now implemented one electronic list that all mediators work from, rather than individual lists. This has created capacity to deal with much more mediations and has increased our appointment slots by 15%. Parties now have a 2-hour time frame in which they may be contacted, rather than previously being given just an AM or PM slot. This reduces the total time that parties have to wait or make themselves available from the period of 5 hours down to 3 hours, which is obviously much more customer focused. This now new list works extremely well for all parties and the mediation team. Our listing processes we are continually reviewing to ensure we maximise the time available for more mediations to take place going forward. In the last year, we have been running an online civil money claims pilot, and this is part of the new digitised civil money claims system. Following a successful pilot, parties now automatically opt out of mediation, and mediation referred opt-out claims are more successful. And this is because parties are more likely to choose to go to mediation, whereas when we previously had a system where you had to opt in, they had to make that choice to opt in. Obviously, the parties still have a choice, but it's as a result of the opt-out pilot, we now have nearly a 40% success rate compared with 23% for opt-in claims. Since the pilot went live, between the period of July and September 2021, there was a 26% increase in claims being referred to mediation compared to the same period in 2020. The current success rate of this pilot, where a mediation appointment takes place, is in the region of 54%. We've also, to improve the information that we provide around mediation, we've updated the digital screens, guidance and notification information for customers following feedback and evaluation from customers. We are currently undertaking a full evaluation of the service to make sure that we make this the most successful mediation service and increase our mediations going forward. Now that's my brief presentation over, and now it's an opportunity for you to ask some questions if you have any. So I'll pass you back. Thank you.
Thank you very, very much, Kirsty. Good afternoon, everyone. I'm Dr. Ryan Wilkinson. I'm a senior data analyst within the Strategy and Change Directorate here in HMCTS, and I am facilitating the Q&A for this session. Thank you again, Kirsty, for a great presentation, and thank you to those people who have already started asking questions via the Q&A tab. And if you have questions for Kirsty, then please feel free to ask them by clicking on the question mark icon in the top right-hand corner of your screen. Kirsty, our first question for you is there, across the entire mediation journey, any additional cost to either party if they agree to mediate?
The short answer is no, and actually if you end up successfully mediating, it is more likely that there will overall be a reduction in your costs overall by the fact that the proceedings are not proceeding anymore. So the answer is in relation to there is no additional cost to opting in or opting out, opting into mediation or automatically being opted in. So yes, the service is completely free and is part of the civil process in relation to small claims.
Fantastic, thank you. Another question that's come in fairly recently is, does mediation take place before a CCJ is entered? And if so, does it stop a CCJ being entered if an agreement is reached?
Yes, a CCJ is only entered at the point that an order is made by a court. Where mediation comes into the process is at the point where the proceedings are very early stages, and it's usually between days 14 and 28 of the court proceedings. So and therefore, and the whole idea of doing it at that point is to see if parties can actually reach a settlement that is agreeable to both, rather than going to a court hearing. And a mediation settlement is always better than having an enforced decision made by the court, and usually a compromise is the best approach. So the answer is it is before.
Fantastic, thank you. Another question that we've had come in, again, fairly recently, thank you again to all of you who are listening and filling in your questions, keep them coming, is, and I don't know how much you'll be able to answer on this, so feel free to say so if something is, if there's not data to support that quite yet, but do you know if there are certain types of people or certain types of cases that are more likely to result in successful mediation?
Yeah, the mediators I'm aware of the types of cases that they generally settle, and quite often they can be parking tickets, travel company mediation, where claims. We also, I'm trying to think of any other ones that are very frequent, but yeah, generally it's quite often types of fixed penalty type civil claims that generally settle more frequently, because often what happens, it's not a dispute about the actual issuing of perhaps the fine, it's more about the fact that it's about the ability to pay, and that is when there is an opportunity through mediation to often make arrangements to pay which allow it to settle before it gets to a court hearing, which is why it's a really useful service for certain types of cases.
Awesome, thank you. Another question says, relating to the fact that you mentioned that people are now able to opt out rather than opt into mediation, and that has had some advantages, at least in terms of people going through mediation and getting a settlement. How many parties are choosing to opt out, say, in this year, or in the year to September 21?
I don't have the exact figures before me, but the figure I gave you before, if I relate back to my slide, was in the region, the ones that were opting towards mediation was up to, I think it was 35%. So I would say that would mean that 65% are currently opting out. Now, previously, when they were opting in, we were only having 23% going through to mediation. So it has increased. The overall figure of that, unfortunately, I haven't got, but I'm happy to take it away and provide the person, if they want to give me an email address, I can, we can take that and give the answer to that question at a later stage, if that would be helpful.
Fantastic, thank you. Someone's asked a very interesting question, maybe interesting to hear your thought on it. So, which is, how can we direct litigants in person to try mediation? Presumably that's coming from the perspective of a legal representative.
Yeah, I mean, we are within HMCTS, we're very conscious about trying to make our communication so it is understandable to all parties, whether they're legally represented or not. And we've been doing a lot with the HMCTS Customer Insight team to see if there's ways, looking at the correspondence that we use, whether it's on the online service or it's in the service that's yet to be digitized, about making the information that we provide our customers in the most straightforward language so that they understand the benefits of mediation. So there's a lot of work being done around that in the background, and we've already made significant improvements in our communication in relation to making it more straightforward, and we're hoping as a result that that is going to increase the opportunities for litigants in person to take up the opportunity of mediation and really understand the benefits to them of doing that.
Great, sounds really, really good. Another question, which is, so you mentioned earlier that mediation settlements try to get done within this hour window, but can mediation go beyond that 1 hour allocated?
Yes, I mean the 1 hour is just a guidance so that we can keep it's a way of listing to make sure that we keep our, you know, as many cases, being able to list as many cases as possible. However, the mediators are have the capability and are able to make a decision on in any particular case as to whether it should go beyond the hour. And if, for instance, they feel that by spending perhaps an extra 10, 15, 30 minutes to reach a mediation appointment, it would be worth continuing beyond the hour, they will do so. The other avenue they have is they've got an opportunity whereby they can ask the parties to reflect on the conversation that they've had during the hour, and they can come back to the mediator in a couple of days to say whether they now to reflect on this decision and mediation to see if they want to finalise that. And again, that's another opportunity to successfully mediate without the pressure of trying to do it there and then on the day. And we found that by offering those two different areas of flexibility, we have seen a lot more cases settling.
That's great. It sounds really good, like flexibility within a framework. So that's always quite encouraging to hear about. Another question that's come in: how does a mediator join the panel of mediators within HMCTS?
Effectively, mediators are a role, a specific role within HMCTS, and they are recruited in the same way that any other role is within the administration of HMCTS. Once they start, they go through a period of intense training, and that is a training programme that has been developed over time with existing mediators, and they do, first of all, a week of intense training, and then they move on to a mentor programme where they're buddied up with another mediator within HMCTS who effectively supports them in the coming months till the coming weeks, going into months, until they're able to mediate on their own. So effectively, that is how we run the internal HMCTS mediation service. I'm aware, obviously, out with HMCTS, there are other panels of mediators that run slightly differently, or there might be membership of different organisations. Our mediation service is very much an in-house HMCTS mediation service, which with our own training support.
Great, thanks for that really, really comprehensive overview. Another question that's come in is, if mediation is not successful, will it have any impact on a judge's decision when if, you know, a CCJ is being made?
I think the answer is no. I think obviously what the judges appreciate is where parties have made the attempt to go to mediation. So in all civil claims, the judge will have asked whether the parties have attempted mediation. So it's not seen upon. I think obviously it's favoured that if they attempt to go to mediation, but if it fails for whatever reason, it's not, you know, obviously when the judge is dealing with it, he's looking at the facts of the case at that point in time. So what happened at mediation, which obviously was confidential at the time, is not taken into any consideration at the point that the judge is then dealing with the hearing. Is looking at everything afresh.
That's always reassuring. Thank you.
Yes.
Another question may be related to, linking in again mediation with reform, thinking about that type of stuff. So are there any plans to use digital services such as online video conferencing or maybe documents only processes instead of the telephone as part of a kind of digital reform program?
It definitely is something that is being looked at in relation to, at the moment we're using telephone, which in some respects now we have the avenue of Microsoft Teams, all different video hearing possibilities. That's one thing that HMCTS is definitely looking at. And it is one thing that, there is a wider review of mediation within HMCTS, and that will be part of that review about how we can use additional digital technology to enable a more successful mediation service, or just a mediation service that effectively is digitized and works with the most modern equipment.
Good stuff, thank you. Somebody has asked, how are, and maybe related to this intensive training that you brought up a couple of questions ago, how are the mediators trained to work out reasonable offers of payment that someone can actually afford to pay? Do you use the Money and Pension Service Standard financial statement?
I don't think that that's necessarily part of it, but I can take it away and answer that question. I think would probably be better rather than me surmising. I've seen the training pack, I understand what it is, but I just don't know the level of detail on that question. So I would rather than answer it incorrectly, I would rather come back to you on that, if that's okay.
I'm sure that is absolutely okay. Another really good question someone's had is, how can we get in contact with the mediation service? Can a litigant in person refer themselves, or do clients have to be invited to mediation?
The information in any small claims, once the proceedings are issued, should be in the correspondence that they get through to you. However, again, there is on the YouGov pages, if you type in small claims mediation, we have information about our service. I'm sure the contact details are on there. It also explains how small claims mediation fits into the wider civil claims process. And I'm convinced there is a contact number on there that tells you that there's a number to get in touch with us. The other thing to say is, even if a case, for instance, if a party, for instance, misses that bit that says, did you want to go to mediation, or even if they made a decision at a given time that they didn't want to go to mediation at that point, but they might, on the run up to a court hearing, might want to be referred back to mediation, that is still a possibility, and the party just needs to get in touch with the local court where the case has gone to and ask if the other party is willing to be referred back to the small claims mediation service. So it is a possibility way beyond the 14 to 28 days that I described at the beginning. But generally, the information about how you go to mediation should be in the information in relation to, if you were defending it, you would get it in the defence paperwork, or if you were issuing it, it would be in that part of that. Obviously, if you have issued proceedings with the new online service, again, there'll be prompts for a claimant to opt out of mediation if they want to, but it gives them some information on the screens around that. But in relation to the defendant, that is then they get the information when it's sent through to tell them that they're defending a claim, or are they a party to the claim. So we do give all parties the information as we go along, but there are a number of areas where we can signpost customers to the mediation service.
Fantastic, thank you. Lots of channels for people to get involved, as it were. how does a mediator spot a statute-barred claim, or where someone really doesn't legally owe all of the claim?
Effectively, it's that they will, I mean, they deal with the information they have before them. If effectively it's a statute barred claim, well, they will get the information out from the parties. But as well, those kind of issues should really have been already looked at when the case was issued. So effectively, that assessment of that will be done on a point of issue. Now, if for whatever reason it is missed, it should be picked up at the point that they get some information on the case. Again, if it is then missed at that point, there is obviously the point when it gets in before a court hearing where effectively it can be looked at again. So there's a number of avenues where it can be picked up, but I would normally say that that should be picked up on issue by effectively when it comes into the court initially.
Brilliant, thank you. There's a couple of questions which I probably lump together because it feels like they might go together a bit thematically. The first one, at least, it should be a really quick one. Somebody missed the very beginning of the talk and just wanted to ask whether is mediation available for all small claims? So I was wondering if you could just go over that very quickly again, and then is it all opt-in or all opt-out, basically?
Yeah, it's slightly mixed, but I'll just go back to the slide so that there is I don't know if that visual is back up there, but effectively the types of cases we deal with all small claims up to a limit of £10,000. There are exceptions to that, is that we do not deal with claims involving child support agency cases, HMRC cases, personal injury over £5,000, road traffic accident involving personal injury claims, and those are statute, that's dictated to us by statute. All other cases are eligible for mediation, and as I highlighted in the slide, these cases are automatically referred to us through the bulk centres where cases have not been allocated, i.e. either through pre-allocation, or they can, as I described before, be referred back at the point that a party says that they would like mediation. Now, I've forgotten, sorry, there was another question tagged to that and I've forgotten now what that is. I don't know if you can just remind me the second part of that question.
Of course, it was just to mention that, so and just to reaffirm, as it were, about opt-in and opt-out.
Oh yes, that's right. So at the moment, we've got the online money claims pilot, which is the new digitised system. And with those cases, any cases up to £10,000, except the exceptions that I've just described to you, that is the opt-out pilot. So there's a presumption in the new digital system that you will go to mediation unless you choose to opt out. Any cases that are currently not on that new digital system will be the opt-in process. Now, eventually, as we continue through reform and we move our processes across, more and more of our cases will then become on that digital system, and therefore they will be opt-out rather than opt-in. But it's just a transition process at the moment while we are running two different types of service. We're running a paper service and we're running an online service currently, but the new digital process is an opt-out process.
Brilliant. And then the relating to that kind of opt-in, opt-out bit, and this is the second question that I was going to link it to. Someone's written, I understood that when the system first changed from opt-in to opt-out, more people opted out and referral numbers to mediation dropped. Has this settled down now?
Yes, and we always thought that there might be something around, because when we originally did it, we did the amounts of in the pilot from £0 to £500 claims. What we've now done is moved, it's not to £10,000 claims, and as a result, that has seen actually more cases remaining in the process than previously. And we always thought it was maybe perhaps to do with the amounts of money in the pilot, as in the limits on the pilot, and that has come to fruition in the fact that since we've moved it to all cases up to £10,000, we're actually now seeing a more successful rate with opt-out than we do with opt-in, which is good. It's pleasing to hear.
Indeed, indeed. Fantastic. We've had one more question that's just come through as well, which you might be able to help us out with, which is where can we, this is presumably again from one of our professional users, where can we direct clients that aren't eligible for your service? Is there another mediation service for claims over £10,000?
I understand in certain pockets of HMCTS there are other pilots ongoing about mediation. I think it varies region to region. So I think my suggestion would be is that if it's in relation to another a claim over, I would refer them to the local court to see if there is an alternative mediation service available, and I'm sure the local court in those regions where there is alternative dispute resolutions kind of pilots and different things going on, that they would be able to highlight those to their client. I'm sorry I'm not more specific about it, but it's you know, as I say, my involvement's generally around the kind of HMCTS small claims mediation service, but I think that would be the best way, I think, that they could find out what else is out there currently.
Fantastic, thank you. And I think we have only one more question that's been asked. So people out there who are listening, feel free to keep asking questions. We've still got a little bit more time, but otherwise, if it remains a little bit quiet, this might be your last question, Kirsty.
Okay.
So this one also involves an acronym that I'm not 100% sure of. So hopefully you can help me out as well. So it's someone has written, we have had cases where unsuccessful mediation has involved an offer greater than the eventual reward, but the DJ, which I presume is district judge, did not award the full hearing fee. In most independent mediations, future costs risks are what drives settlement, but this does not apply in the SCT. Can this drawback be addressed?
I mean, I think what the mediators do is they do explain to both parties the implications of continuing with the proceeding around costs, so that they can understand that if they do carry on and do not narrow the issues between the parties, that they effectively could be liable for future costs. And they also give a kind of indication of the type of cost that could be. Now, we've always, obviously, the mediator needs, you know, it is an independent role and they need to be cautious about how they do that. But they do generally explain to both parties whether one's represented or not. And obviously, the solicitors understand the process better. But if you've got a litigant in person there who doesn't understand the court process, it's explained to them what happens next if they don't mediate. So I think we may not do it in the same way that has been described by the question. However, we are quite clear on what the court process is and the risk to the party if they continue.
Fantastic. There are no more new questions in, so I guess I can just thank you very, very much for that. That's such a broad range of questions. It's been so good to see so many people engaging and asking so many questions. So thank you again, all delegates, and thank you, Kirsty. So I guess it would just be left to me just to say thank you, everybody who's been part of it. Thank you to Kirsty. Thank you to everyone behind the scenes who's been doing their bit as well. And yeah, I just can point you in the direction of our closing Q&A later on this afternoon, and that you can still email in some questions that can be addressed at that Q&A by emailing something into changesomethingthatmatters@justice.gov.uk, as is on the screen right now. But until then, I can only wish you all a good rest of your day, and yeah, thank you for attending the Public User Engagement Event 2021.